All right, that brings us to Kenneth Anschutz and Melissa Anschutz, I think is Melissa Bigler. Is that your last name now?
Yes, Your Honor, and I'm here.
Is Mr. Anschutz here?
Yes.
Okay, good. All right, Ms. Bigler is brought in order to show cause regarding contempt. So I'm going to hear from her first.
Your Honor.
Yes, Ms. Fellows.
This is Beth Fellows, guardian ad litem. I'm actually asking for a continuance. I was not served with the contempt motion and all the documents. I actually got those through the father. So I have not been able to review that whatsoever. So I am asking for a continuance to July 5th.
Ms. Bigler, any response to that?
Yes, Your Honor. I have mailed receipt from the sheriff's office stating that she was served June 14th, I do believe, and it says what she was served with, which was the contempt of court papers in the GAL review evidence review.
What I can tell you, Your Honor, is that it was the motion to review evidence for safety of children and GAL review. That was served by the Cowles County Sheriff's on the 14th, as Ms. Bigler said. Of that paperwork, the contempt motion and all of that was not a part of that.
Okay, Your Honor, I will double check, but all of the papers that I gave to the sheriff's office to have her served with are written on there that I gave them, and it says what she was served with, and it was all in there.
Well, the sheriff's return for Ms. Fellows says order to go to court for contempt hearing, family law calendar notice, GAL review, evidence review, declaration of Melissa Anschutz. Okay. Right now, the children are living primarily with Mr. Anschutz. Is that right?
Yes, Your Honor.
And the visitation with Ms. Bigler, when is your visitation next?
My next visitation is this Friday, June 23rd, and I was also gonna request to have every other week for the summer since there is no school.
Okay. All right, I have, based on what Ms. Bigler has filed, I have certainly some concerns that I was hoping that we would address today. When a party asks for a continuance, at least on the first request, I typically will grant that to make sure that everyone has a chance for a full review before we go to a hearing. So I am going to grant the continuance to July 5th at 9 o'clock. And Ms. Bigler has requested a week on, week off during the summer. I will entertain that request on July 5th. So we'll have to talk about it then. Okay. So that may be something that we address along with the contempt motion at that time. Okay. So this will be over to July 5th at 9 o'clock.
Thank you, Your Honor.
Thank you.
All right, we are being live streamed now. That was a mistake on my part. Okay. So then the next matter is Kenneth Anschutz and Melissa Anschutz. 22-346-8.
I'm here, Your Honor. It's Melissa Bigler now.
Okay. Sorry, I was going from the caption of the case. All right, this is on for show cause matter. Is Mr. Anschutz here?
Yes, I am, Your Honor.
Okay. And I've got a question, the motion hearing, there's a note, evidence for safety of child GAL review. I wasn't clear what the purpose, in looking at the court file, like, wasn't exactly clear what the purpose of the hearing is today, even with that notation.
Your Honor, I filed back at the beginning of June. It was a contempt hearing that I filed, and then I also filed the others because I feel like the children were placed with the father where they shouldn't have been, and I can explain like all my evidence and why as well.
All right, let me just look and. Okay, let's proceed on the contempt matter first.
Sounds good.
I'll hear from Ms. Bigler, I guess, as to why the court should find contempt, and then I'll hear from Mr. Anschutz.
Thank you, Your Honor. The first thing that I want to bring up is one of the biggest concerns that I have, and it shows in the emails between the guardian ad litem and myself that I filed with the contempt papers and the review. Ken had texted me asking if our youngest son is his kid because Ken claims that his eyes are brown when our youngest son's eyes are green. And my daughter said at the dinner table about Camden's eyes being brown in front of myself, my fiance, my youngest son, and my oldest son. And my daughter had claimed that my youngest son wasn't a part of the family. And her saying that she had to have heard it from somewhere else and wouldn't have come up with it on her own. Since then, when I take pictures of my youngest son, he closes his eyes because he's ashamed because he feels like he's not a part of the family. And that is due to his dad not claiming him as his own. For the other contempt charges, most of the claims are shown in the emails that I provided, filed with the court. Ken has parental interference.
What did you say?
He has parental interference when the children are with me. He interferes on my time. My daughter played softball this year, and I was not allowed her softball schedule. I wasn't allowed to attend any of her softball games. I was told I couldn't go. I never received a schedule. I missed every single game because Ken and the guardian ad litem refused to give me the schedule for her softball games.
Did you ever ask the coach for the?
I wasn't given the coach's information. I wasn't given any information for softball, the coach's name. I wasn't given any of that. I asked for it several times, and when Ken wouldn't give it to me, I asked the guardian ad litem, and she never got replied to me.
Okay.
And another thing, Ken refers to me as Melissa to our children when they're with him majority of the time, and he refers to me as Melissa and not mom to my children. And I have provided evidence that was filed for that. Ken has done parental alienation with our children against me, and my relationship with my children is not as great as it should be because of the things that their dad says about me to them. Ken refuses to communicate with me regarding our children. And Ken has also threatened to take time away from me, going against court order. And he has violated a court order about neither parent should make disparaging remarks about the other parent that Commissioner Nelson that we had before had signed back in February. And Ken also has domestic violence, assault violence history with 5 assault, 4 DVs on his record. And I have the case numbers. He has a violent criminal history.
Can I ask you about that?
Yeah.
The final parenting plan was entered in 2022. Are any of those after that final parenting plan was entered?
Yeah, he refers to me as Melissa to my children, has been within the last couple of months of this year.
Wait, no, any of the domestic violence occur since May 17th of 2022 is my question.
No,
Okay,
no, I just wanted to make it known that he does have a violent history.
okay. All right, go ahead.
And that's for the contempt of courts. Those are the main things that he just does things that a parent should not do. And I also would like to, is it okay if I read my declaration? Because it has a lot of it in here also.
I read your declaration and I also read the pleading regarding review evidence for safety of children.
Mm-hmm.
I just wasn't, I guess procedurally I wasn't clear on that, but.
Yeah, and the emails and text messages that I provided and filed with the court also shows everything and backs up my claims that I'm making and that I've been making.
All right. Mr. Anschutz?
So on the eyes thing about my son, that was actually during the divorce. I asked her about Camden because
I'm sorry, I'm
how
what?
she left and everything. For my son's eyes being brown, that was during the divorce. I asked her about that. So I don't know why she's fabricating, saying that my daughter is saying all this stuff. That was just one text to Melissa back in 2001 or 2. This was a long time ago. And then for me referring to her as Melissa, I just looked at the screenshots. It was Thursday, November 10th of 2022. So that was a while ago also. And for the baseball stuff, Melissa was supposed to bring Hannah to her open ceremony, was 15 minutes early. And I guess her and Hannah got in a fight because they couldn't figure out where to park or something. And so that's my interfering by saying, hey, you're supposed to be at your opening ceremonies at 15 minutes early. On the text, it says, make sure mom knows. It doesn't say Melissa, it says mom, that you need to be there 15 minutes early. Sorry. and what else? And I did give her some times for the games and stuff. And I do believe on one of the texts, it says mom is not going to take me. I do believe Melissa took that screenshot. So Melissa actually refused to take the kids or boyfriend. A report to CPS and APS reporting has been reported through state law enforcement is needed and will be made in 24 hours. So CPS, so the stuff that Melissa is actually saying to these kids has been involved in this through Columbia Wellness also. What else did she say? Oh, and my domestic violence stuff. That was when I was 22 years old. So I don't know why she keeps bringing up my past. That has nothing to do with today or anything. So, and the kids are doing great. I do believe I sent off their grades to you. You got a copy of that. They're AB average students. Camden only missed 1.3 days on trimester 3. So I'm just trying to figure out how I'm incompetent by being a dad. It just makes no sense. Like I'm missing money right now because I'm supposed to be at work. This is the second time I'm getting 2 points knocked off for my job for these court dates.
Your Honor, I would like to bring up, I was not aware that Hannah was in counseling, and as a parent, I thought that I was supposed to be informed of this. And for the screenshot that I provided that he says that I wasn't taking her, that was in regards to a drop off. I wasn't driving her to Kelso. I said we were following our court ordered drop off plan that we have. And it is all shown in the screenshots that I provided. And for the claim that her first softball game, he sent me a time to be there, which said 10:45. And then he texted Hannah and told Hannah that we had to be there at 10:30, which was interfering with my time and caused her to get upset, even though we were on time. So that is a lie, because he told me a different time and is trying to tell Hannah a different time and make me look bad. And all of the evidence is in the papers that I filed and shows that he's lying.
Hey, Your Honor, I'm actually looking at the part where it says, was it Tuesday, April 4th? Hey, you have to be at practice at 6:45. So you can change for practice. This is a different practice. And Hannah wrote back to me, which Melissa took her phone and took screenshots of my phone that Hannah had. She said she's not taking me. That day, I had to race down to Woodland, which I was 3 minutes late, which is documented on the GL thing that Missy had wrote to her. So I was 3 minutes late because I was at the practice waiting for Hannah to show up. And I didn't take these screenshots, so.
Yeah, that, Your Honor.
Wait a minute. On the contempt, I don't find a basis for contempt here. As to providing things like softball schedules, looked at the parenting plan, essentially, things like softball schedules, access to school records, medical records, usually both parents have that access to those things. And don't need to rely on the other parent necessarily for get that information. In an ideal world where everybody's getting along, that can work out, but there's not necessarily an obligation to provide a softball schedule.
Your Honor, how am I supposed to
Stop.
prepare?
Stop. I'm here to address your motion. I'm not necessarily here to address all your legal questions. Your motion doesn't rise to a level of contempt. I don't find contempt based on what violation of the parenting plan that's in place. I'm not considering any domestic violence allegations that occurred prior to May 17th of 2022. I looked at the motion regarding essentially for a change of custody. The court found adequate cause to move forward back in late 22 to change the parenting plan that was entered in May of 20. That still has not been resolved and needs to be essentially resolved by a trial, but it's not going to be resolved by a motion. And I understand you have concerns, but those are things that you need to present at trial to address that. In the adequate cause motion, just looking back at the court file, was entered December 14th. Adequate cause was found. Looks like Ms. Fellows was reappointed and there have been a number of motions in front of the court, but really what we need to do is we need to set the matter for trial on the adequate cause issue. Ms. Fellows, were you appointed for adequate cause? Is that correct?
I was appointed way back in October 14th of 2022. It was regarding the petition to modify.
Okay.
And then there was actually a trial because mom was requesting to move with the kids to relocate. That was in front of Judge Evans on November 4th. That was over 2 hours in court, and he denied the motion. So I have been maintaining being the GAL on the case. There have been significant concerns about Camden, the mother getting Camden to school. So it was brought back before the court in December to change the parenting plan because of the concerns that Camden was not getting to school. So the court did fine for that, changed the custody to primary to dad, mom getting every other weekend. And then
That was just a motion hearing in December.
it was to find adequate cause, because adequate cause was never found after the relocation trial. It was kind of fuzzy as I went back into court to look at what Commissioner Nelson had ruled on. So December 14th, I brought it back before the court regarding the adequate cause, and also brought up about the concerns I had. Commissioner Nelson did find that adequate cause was to be found, and that there needed to be a change in the parenting plan.
Okay,
And then in January 25th, we were back in court on a review. The request was to change schools for the kids. That was granted. There was another hearing on the February 1st. That was a contempt hearing brought in by mom. Contempt was not found. There was another hearing on January 22nd. So we've been in front of the court a number of times, often for the same things.
okay. Procedurally, once adequate cause is found, I guess I saw adequate cause being found in December. And adequate cause is just, there are grounds to move forward. Not necessarily that that this was a final order. I perceive the December order to be a temporary order. Temporary change of the current plan. No parenting plan has been entered since. So I'm just trying to figure this record out.
It is a bit convoluted.
Could the parties, and I guess I want to start with Ms. Bigler, what visitation schedule are you currently operating under?
Currently, I have them every other weekend, Fridays, 5:30 PM to Sundays at 6 PM. And I did request, since it's summer, to have them every other week. And it was supposed to be ruled for that today.
When did you make that request?
Our last court date we had 2 weeks ago on June 21st, and Commissioner Nelson said he was gonna make a ruling on that with everything else today.
Hey, Your Honor, can I say something?
1 second. You can, but I just give me a minute.
Alrighty.
I'm looking at the parenting plan was entered May 17th of 2022, which, at least based on the record that I've reviewed, that's the parenting plan there's never been a parenting plan entered since then. There have been lots of motions in front of the court, but no parenting plan entered since May of 2022.
I want to say that I thought that Commissioner Nelson had written some bench orders.
Yeah. Which makes it really, well, yes, I think so. So in December, there was an order effective December 15th. The petitioner, meaning Mr. Anschutz, shall be primary residential parent for the children. The respondent shall have visitation every other weekend beginning December 23rd from Friday at 7 to Sunday at 5. And you're actually operating, well, let me just make sure there's.
The January 25th court hearing was primarily about changing schools.
Yeah, I saw that.
Your Honor, the bench order I have is from February 23rd of this year. That says my visitations shall be modified to be Friday at 5:30 PM to Sunday at 6.
Okay, and I'm just reading that right now.
Yeah.
Okay, I see that.
And her time should also include school holidays and in-service days if it attaches to her weekend.
All right, Mr. Anschutz, what did you want to say?
Commissioner Nelson said he would entertain the idea of 1 week on, or no, more time, he said. He didn't say 1 week on, 1 week off. He said more time for the summer. He didn't say he's going to make a decision. That's the only thing I remember.
Okay. And I guess I have this question for each of you, and I understand your answers may be different, but did you understand that these written the orders were final modifications of your parenting plan?
I was not aware they were final. Everything that I have and that I was aware of, they were temporary.
I do believe I was informed. I do believe, right? Weren't we? Yeah.
I'm sorry, say that again.
I do believe I was informed, wasn't I? Yeah. Yeah, I was.
Okay. So I think to me, it's pretty clear that the parenting plan needs to be finalized rather than continuing to do these things sort of piecemeal. What I need each party to do is I need you each to file a proposed parenting plan with the court, because it looks to me like the May of 2020, the May 17th parenting plan essentially isn't being followed, and we're just a year beyond that. Not exactly sure how we got to the point we're at, but I need each party to file a proposed parenting plan. And in light of, but here's the context to that. That's not just, this is what I want in a perfect world, but in context of where we are, because the only adequate cause that's been found here comes from that order on December 15th. Court finds cause to modify the current parenting plan. And it's based on a new job. So there really hasn't been grounds to just reopen everything and say, gee, the primary plan should be changed. If there are and the May 17th, 22nd plan had a number of restrictions in it that it doesn't appear to me. I'm not sure how those were addressed. But it seems like the parties have sort of moved on from that. And there aren't necessarily the restrictions that were in place then. So I think we need so I guess I want the parties to file what it is you want in terms of a parenting plan. And then the court can address that. I don't have any terms of making an order regarding summer visitation. I don't have any basis to do that at this point. That was an oral request made of somebody else in a hearing, and there's no written motion, nothing that set out why that should happen. And there's no provision in the original plan for summer visitation being any different than school year visitation. The current plan has those being the same. School year and summer visitation are the same under the current plan. So if Ms. Bigler, if you wanted to change that summer visitation, essentially you would have to show adequate cause as to why that portion of the plan should be changed. And so you would need to file a motion to that effect.
Your Honor, I do, and to that, I do have a question. If everything is based off of the old parenting plan for May of last year, we had every other week. So I don't understand how I've done anything wrong to get my summer visitations taken away.
I didn't see it being every other week. Let me just look at it. It's kind of a it says limitations on a parent. There are parent abandonment, neglect findings as to Melissa. And it says evaluation and treatment are required.
That was complete, Your Honor.
Okay. Then it says school schedule does not apply. And it says school age, or excuse me, underage school, under school age children does not apply. School age children immediately reside with Melissa except when they are scheduled to live with Kenneth. And then it goes on. Sunday at 10 to Sunday at 6. First and third week of the month from Sunday at 10. So this was in every other week. Oh, gosh.
If I recall correctly, I believe they were doing a week on, week off. Essentially. Which became an issue when Mom moved to Vancouver. And so that's kind of how we got to the every other weekend.
Okay.
And again, we had the trial with Judge Evans November 4th.
That was
20
that was a relocation issue that I don't know that really. So then, the December order really didn't. Technically, what the December order did was it changed everything. And then that was modified slightly and just regarding basically an hour or two here or there in that February order. So the current order is the February order, I guess. Not, I guess, I shouldn't say. The February order is the current order. So what we need to address is. Yeah, and I guess I don't have a way of knowing if what the commissioner was thinking in terms of whether this would have any impact on the summer or not. But the summer schedule is the same as the school schedule, and so I guess what I want is I do want proposed parenting plans from both parties that address both the school year and the summer. And I at this point, I'm just. So Ms. Fellows, are you currently actively working the case in terms of doing something to prepare a report for the court?
Yes, at this point, Dad has not fully paid for the GAL fees, so I am kind of actively working it, but he needs to pay those fees in full. He's made a few payments, but he owes probably about $650 still. So although I do have seen the kids and have been working the case, I'm not in a position right now to fully write the report and things like that.
Mr. Anschutz, when can you have that fee paid?
It's kind of hard because I have 2 car payments and rent, and then I pay for all the kids. So I've been giving Beth like $100 here, $50 there. So money's kind of tight, but I got a new job 3 months ago, so I told Beth that we could work on that.
Okay.
And I can make another payment Friday. I get paid Friday. I can make what, $300 if she wants me to come in and do that.
Okay, so pay $300 Friday. When can you have this paid in full?
What do you think? By the end of this month? This guy, the birthday party. We're gonna try for the end of this month. We have a birthday party we have to pay for also.
Have it paid in full by August 15th.
Yeah, I'll try to get it. I'll definitely try, yes.
Okay, well, the end of this month is that you threw out there was July 31st, so I'm giving you a little more time than that, so.
Sure. Thank you.
300 this Friday and the balance by August 15th.
Okay,
Then I need both parents to file proposed parenting plans. And I want to review this on Friday. Let's see. July 28th. And I want to say a few things. It doesn't appear to me that, well, from what I can tell from the orders, what's in effect now and what is in effect now is the every other weekend schedule with no change in the summer. If the I can't tell from the record if the commissioner wanted to do anything different in the summer, but apparently he was open to considering that. So if the parties can come to any agreement about the summer, great. If you can't, I will address that on the 28th as to your proposals. And I realize that cuts into the summer significantly. So it may be that I will I think didn't seem to me that there were any grounds. No, I don't have anything more. I just want to see what the parties' proposals are. And I want to review this on July 28th. That'll be at 8:45 docket. It's that's on my presentation docket. It's Friday morning at 8:45. It's a Zoom hearing. So exchange proposed parenting plans by July 14th. And then I'll review those on the 28th. And we'll see where we are then.
Your Honor, I just want a clarification of what you just said. Am I supposed to communicate with Ken about getting extra time with my children during the summer or not? Even if it's a couple extra days.
Yeah, to the extent that right now the order doesn't allow for that. But I would encourage the parties to communicate about that. If you can come up with an agreement, that's ideal. But if you can't, I will address it at the end of July.
Your Honor, I would have no problem with communicating with Melissa, but every time we communicate, she uses every text against me. So is there like a way we can like third party contact between each other? Because I'm talking every text, she turns it around on me.
At this point, I'm not going to dictate how the two of you communicate. You've got till the 14th to present parenting plans. If you look at each other's proposed plans, and see that there might be some middle ground. That's up to, you know, what you communicate is up to you. And I will, by the 28th, I will have some decisions for you about moving forward.
All right, thank you.
So our next hearing, July 28th at 8:45, correct?
Yes, Zoom.
Okay, thank you, Your Honor.
Thank you.